Microphone. I welcome you all to the 2020 Patrons Address, the 9th annual Patrons Address held by the Australian Academy of Law. My name is Alan Robertson, President of the Australian Academy of Law. I particularly welcome Her Excellency the Governor of New South Wales and Mr. Dennis Wilson. I pay respect to the traditional owners of the lands on which we gather and to their elders past, present and emerging. In particular, I pay respect to the Gadigal people of the Eora Nation.
I don't want to be seen.
It is my great privilege and pleasure to introduce Her Excellency, the Honourable Margaret Beazley, AC QC, the Governor of New South Wales. I'm grateful to Her Excellency, a Fellow of the Academy, for agreeing to deliver today's Patrons Address. As you all know, the patron of the Academy is Chief Justice Susan Kiefel, AC. If you were to look at the Vice-Regal program, you would see what a schedule the Governor has. If you were to look at Her Excellency's curriculum vitae, you would realise I have time to mention only a small part of it. Margaret Beazley was called to the Bar of New South Wales in 1975. She was appointed Queen's Counsel in 1989. She was appointed a Judge of the Federal Court of Australia in 1993. And in 1996, she was appointed to the Supreme Court of New South Wales as a Judge of Appeal and was appointed President of that court in 2013. In May 2019, she was appointed the 39th Governor of New South Wales. In 2008, Her Excellency was awarded an Honorary Doctorate of Laws by the University of Sydney, and in 2019, an Honorary Doctorate of Laws by the Australian Catholic University. The subject of Her Excellency's address is Aboriginal Australians and the common law. I now introduce the Honourable Margaret Beazley, Her Excellency.
Thank you, Alan. Wujuri Gamarua, Babana Majingal, Gamarado, Gadigal. Thank you for this very honoured privilege of presenting today's lecture, the title of which is Aboriginal Australians and the Common Law, a topic which is ambitious in both its potential breadth and in its depth. My aim in this lecture is to provide an historical exposition of what has occurred in the common law to date. Indeed, as Governor of New South Wales, it is not appropriate for me to do otherwise or to do more. It's certainly been challenging, but at the same time, it has been rewarding for the insights that I've gained in studying this particular aspect of the Aboriginal history of Australia. I suspect that over the next 50 minutes or so, you too will find it a challenge to listen to because it's fairly dense. I trust, however, that you will leave today with a little more knowledge than you had when you came online. The rightful place of Aboriginal Australians in this country is a topic in which all Australians are or are becoming increasingly invested. However, relationship without understanding and investment without knowledge has a hollow ring. Indeed, 4 decades after the end of World War II, the President of the Federal Republic of Germany said, "Anyone who closes his eyes to the past is blind to the present. Whoever refuses to remember the inhumanity is prone to the risks of reinfection." Because the topic is large, and there is a wealth of academic commentary, particularly on Mabo and on native title jurisprudence, I've chosen to confine my remarks to 3 areas: 19th century Aboriginal interaction with the common law, Aboriginal identity, and sovereignty. In doing so, it has been necessary to navigate, but necessarily very selectively, over 230 years of legislative and curial history. There are some historical facts which put tonight's topic, especially that of sovereignty, into perspective. First, Captain Cook's instructions from the Lords of the Admiralty were, and I quote, "with the consent of the natives, to take possession of convenient situations in the country in the name of the King of Great Britain. On the 23rd of August, 1770, having sailed 1,800 miles along the east coast of Australia, Cook claimed possession of the whole of the east coast from latitude 38 degrees south in the name of the King. On the 25th of April 1787, Governor Phillip received his draft instructions from King George III, in which Phillip was directed to endeavour by every possible means to open an intercourse with the natives and to conciliate their affections, enjoining all our subjects to live in amity and kindness with them. Although arriving in Botany Bay on the 26th of January 1788, Phillip did not proclaim the colony of New South Wales until the 7th of February in a ceremony performed by Judge Advocate David Collins at Sydney Cove. That brings me swiftly to the doctrine of terra nullius, literally nobody's land. It is apparent from Cook's journal and Phillip's instructions that the literal meaning of terra nullius never applied to Australia. Indeed, its literal meaning never really operated as a principle of international law. Rather, throughout the 16th to the 18th centuries, the term terra nullius was little used, and to the extent that it was used by historians, philosophers, and lawyers, it had two distinct meanings. The first meaning referred to land devoid of human possession, morally considered to be free for the taking. But the devoidness of human possession strictly was a reference to the ownership of real estate. This version of terra nullius is associated with writers such as Emeric de Vattel and Samuel Purchas, whose vision of the Aboriginal populations was that they ranged rather than inhabited unmanned wild country, and further, that cultivating land in a manner recognisable by European cultures was a requisite feature of any claim to ownership. The second meaning referred to land without a sovereign, without political organisation, recognisable systems of authority or legal codes. It is this sense which became incorporated into Australian law. In Cooper and Stewart, the question was whether the English law of perpetuities was part of the law of New South Wales. That depended on how English law was introduced into the colony, which in turn depended upon whether the colony had been acquired by conquest, cession, or settlement. It was the latter that the Privy Council considered applied in New South Wales, which their lordships described as a tract of territory practically unoccupied, without settled inhabitants or settled law at the time when it was peaceably annexed. Thus, English law was introduced into the colony from the outset, as expounded by Blackstone in accordance with the silent operation of constitutional principles of the law of England. Their lordships in Cooper and Stewart continued. Insofar as it is reasonably applicable to the circumstances of the colony, the law of England must prevail until it is abrogated or modified either by ordinance or statute. And I'm sure you know that in Cooper and Stewart it was found that the law of perpetuities was not reasonably applicable to the colony. A significant feature of acquisition by settlement was that land vested in the Crown from the time of first settlement in New South Wales in 1788, as the Supreme Court of New South Wales held in 1847 in Attorney General against Brown. These principles of the law of nations underlie the development of the common law in Australia. As Justice Brennan said in Mabo, this enlarged notion of terra nullius was equated with Crown ownership of the lands therein because there was no other proprietor of such lands. In determining whether native title was part of the common law of Australia, Justice Brennan considered that there was a choice of legal principle to be made, either to apply existing authority or to overrule it, discarding the distinction between inhabited colonies that were terra nullius and those that were not. In the result, Mabo established that the common law of Australia recognised native title, which, however, or that recognition did not impinge upon the radical title of the Crown. As a settled colony, questions of jurisdiction in respect of the Aboriginal population arose almost immediately. There were language difficulties and few interpreters. And most significantly, Aboriginal persons were not permitted to give evidence. In 1799, Thomas Hewitt was charged with the murder of Willie Cuthie, an Aboriginal man. He was acquitted by the court on the basis that Cuthie's widow was incapacitated from giving such testimony as could be admissible by or in law to affect that life of the prisoner as he was by the court. In 1805, Judge Advocate Richard Atkins refused to permit evidence from an Aboriginal person on the basis that evidence of persons not bound by any moral or religious tie can never be considered or construed as legal evidence. Not even proficiency in English was sufficient for an Aboriginal person to give evidence, as Daniel Mawati found to his disadvantage. Indeed, he suffered a double whammy. Having lived most of his life amongst the white population, it was held he was amenable to the jurisdiction of the criminal court. As recorded in the Sydney Gazette of the 28th of September 1860, Mawati was described as a morally and culturally liminal man, liminal meaning transitional or initial stage of a process, and he thus was considered to have a clear and conscious discrimination between good and evil. There was a sad and ironic ending to Mawati's life. Having been brought up since infancy by Richard Partridge, the then colony's hangman, he was found guilty of rape and was hung on the 1st of November 1816, a fate that was duly recorded in Governor Macquarie's diary. I'm just pleased that I don't have to keep such a diary. The Attorney General of the time was insistent that English law applied to all persons regardless of their language proficiency. However, the early judges took a different view. Judge Darling, concerned that English law required that a person brought before the court was entitled to know the law under which they were being tried, attempted to ensure that the spirit and the letter of the English law was not departed from. Aboriginal prisoners often found themselves remanded in custody until an interpreter could be found as a result of the view that justice had taken that they should know with what they were charged and how the process worked. This could mean many months in custody, as Devil, charged with aggravated assault of a white man, Jeremiah Buffy, found out in 1825 when he was remanded in custody for 7 months. In the 1835 trial of Mickey and Muscle, Judge Burton expressed the matter in these terms: "The English culprit stands on very different grounds from the native black. The former knows something of the law under which he is tried, understands every word of what is said, objects, cross-examines, calls his exculpatory evidence, and avails himself of manifold circumstances and finesses of which the latter, that is, the Aboriginal person, is utterly ignorant." Judge Burton continued, "There stands the savage, mute because he could not give evidence, and a helpless spectator of a scene in which his life is at stake." Despite Judge Burton's doubt as to Mickey's guilt in that trial, he was nonetheless convicted by the jury for rape of a female servant and sentenced to death, the second execution of an Indigenous person in New South Wales. Coming back 6 years, in 1829, in R.V. Ballard, the Supreme Court ruled it had no jurisdiction where only Aboriginals were involved. Ballard had killed another Aboriginal. The Attorney General twice sought the opinion of the court on the question of jurisdiction, first of Chief Justice Forbes and then of the full court. Chief Justice Forbes, sitting alone, in similar terms to what had been said in Mawati, said he could perceive of circumstances where an Indigenous person would be amenable to English law, if, for example, the person lived with the town and by such residence had placed himself within the protection of the municipal law. However, if a dispute arose within a tribe and the matter had been decided by the custom of the tribe, namely by battle, as had been the custom in ancient England, then the matter would not be cognisable by our law. On the hearing in the full court, Chief Justice Forbes reiterated that he knew of no principle of municipal or national law which shall subject the inhabitants of a newly found country to the operation of the laws of the finders in matters of dispute, injury or aggression between themselves. He also doubted that there was any advantage in granting British institutions upon the natural system which savages have adopted for their own government and to which they adhered rigidly. However, he adhered to the already settled position that this rule did not apply in respect of interactions between the English and Aboriginal populations. Judge Darling was also of the view that the Indigenous people owed no fealty to the British system of law and over whom we have no natural claim of acknowledgement or supremacy. Ballard is to be contrasted with the 1836 decision of R.V. Murrell, where the Supreme Court held that it had jurisdiction over all people, with no distinction in respect of disputes solely between Aboriginal persons. When the matter came before the full court, Murrell's barrister, Sidney Stephen, who was the brother of the Chief Justice Alfred Stephen, challenged the accepted basis of English occupation of the colony as being neither by conquest, cession or settlement of a deserted, uncultivated land. He was a little ahead of his time. Rather, he argued that the Aboriginal population had customs of their own and that the English had come to reside amongst them. Therefore, in point of strictness and analogy to our law, we, the English, were bound to obey their laws, not they to obey ours. Relying on the principle that those subject to the law were to be afforded its protection, he argued alternatively that the Aboriginal population were not bound by laws which did not at the same time afford them protection, given that they were not admitted witnesses in the courts of justice, they could not claim any civil rights, they could not obtain recovery of or compensation for their lands. And he added, in case he was on a losing argument, that if amenable to English law, Murrell was still subject to customary law and thus liable to double punishment at the hands of the victim's family, principle of law which still adheres in the sense of extrajudicial punishment. Although Chief Justice Forbes had initially maintained the position he took in R.V. Ballard, when the matter came before the full court, over which he presided, all arguments put forward on behalf of Mr. Murrell were rejected on the basis that the Aboriginal populations were not a sovereign people, that the English had taken possession of the land so that English common and statutory law applied in accordance with Blackstone's principles, and that the Supreme Court had been invested with jurisdiction by the Australian Courts Act of 1829 over all civil and criminal matters whatsoever. Trials of the times raised all sorts of issues, including the types of issues which continue to vex modern criminal trials, such as pleas of autre acquit, the sufficient particularity of the charge in the indictment, the weight of circumstantial evidence, and whether there was a case to go to the jury. All of those issues arose in the 1838 trial of Charles Kilmeister and 6 others for what was recognised in the judgment of Judge Burton as the massacre of Aboriginal persons at Mile Lakes. Found guilty, the 7 defendants were sentenced to death by hanging. 6 other defendants were never put on trial. In 1841, sitting in the District Court of Port Phillip, Judge Willis didn't consider himself bound by Murrell. In the case of Bonjon, Judge Willis examined the history of the settlement of New South Wales, did an extensive review of the relevant principles of the law of nations, quoted extensively from de Vattel, and referred to the address of the British Commons to the King in 1834, in which it was stated that it might be presumed the native inhabitants of any land have an incontrovertible right to their own soil, and a sacred right which seems not to have been understood. Judge Willis also referred to correspondence between John Batman and the Colonial Secretary in London in 1835, which described the Aboriginal population as being neither devoid of intelligence nor destitute of capacity, and of a superior race to any natives which he had ever seen. In referring to this, Judge Willis described the Aboriginal population as having laws and usages of their own. Willis also undertook a comparative historical and legal examination of other jurisdictions, including whether there had been treaty arrangements, noting that where treaties had been entered into, land had not been taken without compensation, but had been subject to negotiation. Examining the statute of 9 George IV, Willis observed that there was nothing in that act, nor in any other law of which he was aware, that makes Aborigines subject to our colonial code, noting that section 24 of the statute declared that the laws of England shall be applied to the administration of justice so far as circumstances will admit. He stated that was very different from declaring that the Aborigines shall, as amongst themselves, be amenable to British law. Willis continued and set out lengthy passages from the 1837 Aborigines report of the British Select Committee relating to the Indigenous peoples of the various British colonies. This report is steeped in Christian humanitarian ideology, distinguishing savage natives from European civilised society. Nonetheless, it recognised that the native inhabitants of any land have an incontrovertible right to their own soil, a plain and sacred right which seems not to have been understood. Referring again to the statute, Willis said that English law, being only necessary for the protection and due regulation of intercourse between the English and Aboriginal populations, he was strongly led to infer that the Aboriginal population must be considered and dealt with as distinct though dependent tribes governed amongst themselves by their own rude laws and customs. This, in effect, was a reference to the notion of a domestic dependent nation, to which I will refer in a moment. The prosecutor, for his own reasons, perhaps subsequently declined to proceed with the case. In correspondence from Chief Justice Darling with Willis, Willis was sternly rebuked by the Chief Justice on the basis that Murrell had settled the question of jurisdiction, which he said, the Chief Justice said, would have been reinforced had Bonjon ever gone on appeal. And this was the view of the law that was subsequently accepted by Governor Gipps and the British government. The notion of a domestic dependent nation was explained in the United States jurisprudence of the first half of the 19th century relating to Indian claims to sovereignty. In essence, that principle recognised that a native people were entitled to possession and use of their land and to exercise de facto rights of sovereignty over it, subject to the ultimate dominion of the discoverer. Judge Willis's views were not idiosyncratic. In 1841, James Stephen, who was described in Mabo as probably the most knowledgeable of all the 19th century permanent heads of the Imperial Colonial Office, noted a communication from the South Australian Colonial Office that it is an important and unexpected fact that these tribes had proprietary rights in the soil, that is, in particular sections of it which were clearly defined or well understood before the occupation of their country. The issues to which I have referred, language, interpreters, ability to give evidence, all have their analogues in the 20th century case law. In microcosm, these questions can be found in the decade between 1951 and 1960 in decisions of the Supreme Court of the Northern Territory in the judgments of Justice Crywalt. Justice Crywalt was credited by the Australian Law Reform Commission with introducing a degree of cultural sensitivity into the criminal law by taking account of the local circumstances. Crywalt's understanding of the language difficulties encountered by Aboriginal Australians in the court system and his approach to sentencing was the basis upon which the Law Reform Commission made its comment. However, Crywalt's judgments reflected his avowedly assimilationist philosophy. Although he sought to protect Aboriginal Australians from the unjust application of the law, a superior Christianised stance pervaded his judgments, apparent in relation to his approach to evidence, interpreters, penalty, which very much depended on the degree of an Aboriginal defendant's civilisation, and Aboriginal identity. Perhaps the most striking was his approach to the equality of Aboriginal evidence. The Northern Territory Evidence Ordinance of 1939 provided that non-Christians, including Aboriginals, could give unsworn evidence after being warned to tell the truth, but with the qualification in relation to Aboriginal witnesses that the jury could determine what weight to give to their evidence. In the absence of a spiritual sanction or a higher tribunal to act as an encouragement to truth-telling, Justice Crywell's directions to the jury downgraded the credibility of evidence given by Aboriginal witnesses. The jury direction in the trial of 3 white defendants charged with assaulting a number of Aboriginal people with stockwhips makes the point. The direction was, over and above the fact that evidence is given by natives, regard shall be had to the fact that evidence is unsworn. One should think twice before one decides to accept the evidence of natives. Justice Crywell considered that, generally speaking, an Aboriginal's intellect is of a comparatively low standard. He was prepared to accept that Aboriginals had a native shrewdness, but expressed difficulty in understanding the processes of the native mind. In one case, His Honour attributed the reluctance of a young Aboriginal person to give evidence against her father, charged with her sexual assault. He attributed that reluctance to her Aboriginal blood, which he calculated to be 5/8. And I pause just to remark that that young person, who happened to be Rosie Kunoth, who played the role of Jeddah in the Australian film of that name, would not have been the first victim of a sexual assault, especially in the secretive atmosphere of the 1950s, who was reluctant to give evidence against a father or other relative, or indeed any other person. Although the titular theme of this paper is Aboriginal Australians and the common law, the constitutional and the legislative paradigm has significantly controlled the interface of Aboriginal Australians and the law. Until Mabo and Love and Toms, Aboriginal identity depended significantly upon the large volume of ordinances enacted by the Australian states and territories. In his 1986 paper, McCorquodale reported on his analysis of 700 different legislative instruments, producing 67 different classifications, descriptions or definitions of an Aboriginal person between 1788 and 1986, which he grouped under 6 main headings: anthropometric or racial identification, territorial habitation, affiliation or attachment, blood or lineal grouping, including descent, subjective identification, exclusionary and other, and Torres Strait Islanders. Stated generally, the ordinances reflected the white protectionism and assimilationist policies of the time. Many ordinances described an Aboriginal person in what might be described as quantitative notions of Aboriginality, with inclusion or exclusion as an Aboriginal, depending upon the subject matter of the ordinance. In other instruments, identity was permitted to be determined by mere observation, including judicial observation or by administrative discretion. The legislative language, especially that in the 19th century ordinances, could be jarring. For example, the Masters and Servants Statute of the Victorian Masters and Servants Statute of 1864 did not apply to any native or any savage or any uncivilised tribe. Different states had different bases upon which Aboriginal Australians were recognised as or as not being Aboriginal. In Western Australia, civilised Aboriginals were recognised in its population count. In Victoria and Tasmania, half-castes were recognised as part of their populations. From 1936 to 1960, in Western Australia, a native was a full-blood Aboriginal person or a person who was greater than 1/4 of the original full-blood. Quadroons, or 1/4, Aboriginals were not subject to the legislation if they were under 21 and did not associate with or live substantially after the manner of natives, but they could be classified as native by order of a magistrate or at their own request. For any person with less than quadroon blood, born prior to the 31st of December 1936, only an express application under the Act approved by the Minister enabled a claim to native status. And in the Native Welfare Act of 1963 of Western Australia, the definition of native excluded quarter castes. In the Native Administration Act Amendment Act 1954, still a Western Australian Act, a person could be deemed to be no longer a native if he had served as a member of the armed forces outside the Commonwealth or for at least 6 months within Australia and was entitled to an honourable discharge. As Corkadale points out, within and between states, definitions of Aborigine operated differently at different levels of subject matter and advancing either in beneficence or in control. Thus, half-castes might be put on the same footing with full-bloods for some purposes, testimony and liquor in particular, but not others, for example, reserves and guardianship of children. McCorkdale found only 2 cases in 180 years where an Aboriginal person challenged their legal status under the varying legislative provisions relating to their Aboriginal identity, although there were a number of challenges by Europeans charged with liquor offences. So, in Branch and Skeets, Mr. Skeets successfully appealed his conviction for the supply of liquor to a Mr. Bond, who was the son of a full-blood and a half-caste mother. It was held that Aboriginal natives under Section 48 of the Liquor Act of 1898 only applied to full-bloods, and that any trace of white blood would invalidate a claim to being Aboriginal. And you might expect Mr. Skeets was acquitted from supplying liquor to an Aboriginal. Until 1964, it was an offence to supply liquor in the Northern Territory to an Aboriginal person. Up until 1953, albeit that half-caste was a defined term, the Aboriginals' ordinance permitted that the court could decide by personal inspection whether a person was or was not a half-caste. The Chief Protector of Aborigines could also deem a person not to be a half-caste, and if legally married to a person of substantially European descent, a female half-caste was no longer considered to be an Aboriginal under the ordinance. Under the Welfare Ordinance of 1953, which didn't commence in operation until 1957, the legislative language changed from half-caste to wards. But despite the apparent neutrality of its language, the ordinance was in fact directed to the entire Aboriginal population of the Territory. This was borne out when administrative action taken under the ordinance resulted in a block declaration by the Chief Protector that 15,211 persons, all Aboriginal, were wards of the Territory, and only a small number of transient aliens and a few others were accepted from its reach. Renowned artist Albert Nematajira, in his prosecution for illegally supplying liquor to his mate Henok Rabaraba, who was a ward under this ordinance, unsuccessfully challenged the validity of the ordinance and the validity of the declaration made by the Chief Protector, given that no person that was subject to the declaration had been given a right to be heard. In refusing special leave to appeal, the High Court stated that this bulk declaration of Aboriginal people as wards under the ordinance was valid, despite no notice having been given to the individuals who fell under its umbrella, which was all of the Aboriginals in the Territory. First, because the status of ward was effectively confined to Aboriginals, who were persons who might be regarded as a class in need of such special care or assistance as was provided for in the ordinance. And secondly, as such administrative declarations could be appealed at any time, there was no infringement of the right to be heard in respect of the administrative action that had been taken by the Chief Protector. So, for sharing a bottle of rum with his friend, although there was no evidence that Nematajira actually directly passed the bottle to Rabaraba, Nematajira was sentenced to 6 months hard labour, reduced to 3 months on appeal. That was 1958. In 1971, Mervyn Eads was convicted for failing to register for national service under the National Services Act 1951 of the Commonwealth, But of course, in 1971, we were in the era of the Vietnam War. Under the National Service Act, Aboriginal natives were defined to mean full-blooded or half-caste, or a person with an admixture of Aboriginal blood who lives as an Aboriginal native or amongst Aborigines. All of those persons, as defined as Aboriginal, were exempted from national service. Mervinese, although of Aboriginal descent and having spent the first 10 years or so living on an Aboriginal reserve, and as classified as an Aboriginal under Western Australian legislation as 3/8 Aboriginal, was held not to fall within the definition of Aboriginal under the Commonwealth legislation. He was therefore not an Aboriginal under the Commonwealth legislation, and therefore he was not exempt from national service, and he therefore was convicted for his failure to register for national service. The reason? He lived in a house, albeit owned by the Native Welfare Department, in an area occupied by white citizens, and was generally in regular employment, dressed well, owned a car, and travelled to Perth from Geraldton 3 times a year to visit his friends and relatives. In effect, he was not Aboriginal because he had successfully assimilated. This exemption clause caused a great deal of confusion. There were many examples where young Aboriginal men were variously told to register or not register for national service, or indeed who tried to register for national service as a gesture, indeed a protest that they were equal. And the surrounding confusion was summed up by Vietnam veteran Glenn James, who recalled, "I was 20 when I got a notice to say I was called up for national service. Then I got a notice to say I didn't need to go because I was Aboriginal. Then I got a third notice to say I had to go after all. I tell you, that put a damp outlook on the whole thing right from the start. I was going, then I wasn't going, and they'd raised this question of Aboriginality right at the start." At common law, and here I quote from Justice Brennan in Mabo, an Aboriginal person is a person of Aboriginal descent, albeit mixed, who identifies as such and who is recognised by the Aboriginal community as Aboriginal. But that's not the last word. Aboriginal identity remains relevant in a number of statutory contexts, including eligibility for membership of and election to various councils and previously to ATSIC, and in respect of legislative instruments, including discrimination legislation. In the Aboriginal and Torres Strait Islander Commission Act of 1989, and that was the in the Aboriginal and Torres Strait Islander Commission Act of 1989, Aboriginal person was defined as a person of the Aboriginal race of Australia. In Gibbs and Capewell, Justice Drummond required, in addition to Aboriginal descent, identification or communal recognition. In another case, in Shaw and Wolfe, Justice Merkel held that all 3 components of Aboriginality were necessary to be an Aboriginal person within the definition. On the 16th of October 1987, letters patent were issued establishing the Royal Commission into Aboriginal Deaths in Custody. In Attorney General in Queensland, the question arose as to the Commissioner's authority to inquire into the death of a person of partial Aboriginal descent. In that case, Justice Spender was of the view that non-trivial descent was sufficient, but that self-recognition or community acceptance might be of evidentiary value in contested questions. For Justice Jenkinson, descent was necessary but not sufficient. And for Justice French, descent of itself was sufficient, having regard to the context in which the question was being determined. In Eatock and Bolt, the complainant, who was a fair-skinned Aboriginal, successfully claimed that there had been a contravention of the racial vilification provisions of the Commonwealth Racial Discrimination Act of 1975 in newspaper articles that contended that she and people like her were not genuinely Aboriginal and only claimed to be so to obtain the benefits solely available to Aboriginal people. After referring to the various tests of Aboriginality in the case law, the court held that genuine self-identification by a person with limited Aboriginal descent could, as a matter of the ordinary understanding, be regarded as Aboriginal, even without communal acceptance. Given the history of separation of Aboriginal children from their parents, this could occur where a person only latterly discovered their Aboriginality and wished to acknowledge that heritage, but had not had the time, the opportunity, or the connections to obtain communal acceptance. It has been apparent to us as we have spoken to many Aboriginal people over the last 18 months that identity is a significant issue. Anecdotally, we are told of stories where Aboriginal people, now in their 50s and their 60s, were told not to speak the language and not to indicate that they were Aboriginal, just in case they were snatched off the streets. So these anecdotal stories are powerful, but for myself, that review of the extraordinary range of definitions of persons must have created extraordinary confusion and harm and I think feelings of dispossession. Customary law has also played its part in the common law. There was the 1986 Law Reform Commission's report on the recognition of Aboriginal customary law, and it made recommendations supporting the recognition of Aboriginal customary laws by our judicial and administrative authorities, both in procedural and substantive law. The Commission found that customary law had only been accepted in a few exceptional and irregular circumstances on topics relating to land rights, customary marriages, and child custody. In the 1861 decision of Neddy Monkey's wife was deemed to be compellable to give evidence against her husband during his trial for murder on the basis that the court could not take judicial notice of the religious ceremonies and rites of these people and cannot, without evidence of their marriage ceremonies, assume the fact of marriage. 60 years later, in 1934, in Tuckia's case, Tuckia's wife, Japari, was not compelled to give evidence against her husband during his trial for the murder of Police Constable Albert Stewart McCall in recognition of their marriage according to Aboriginal custom. So just the reverse. The Criminal Law Amendment Ordinance of 1939 of the Northern Territory distinguished between white persons and Aboriginal persons living in the Northern Territory during the 50s, creating an environment where customary law was relevant to sentencing in murder cases. For white people found guilty of murder, their ultimate sentence was the death penalty unless the royal prerogative of mercy was exercised. For an Aboriginal person, the judge was required to receive and consider any evidence which may be tendered as to any relative native law or custom and its applications to the facts of the case. Justice Quaywalt, in Jangala's case, when sentencing an Aboriginal man convicted of manslaughter for killing his victim by hitting him with a stick, explained his duty to impose a more severe sentence than he normally would for death, a death case resulting from fights between natives, on the grounds that the accused has by now sufficient knowledge of white law to know that he was acting illegally. The Royal Commission's recommendations were only partially implemented, with provisions introduced into the Crimes Act, the Commonwealth Crimes Act, relating to criminal investigations involving Aboriginal or Torres Strait Islanders and fishing, hunting and gathering rights under native title law. However, the last 34 years has seen judicial acceptance of customary law in circumstances not only in Mabo but in different, notably in Wick relating to pastoral leases and Yenna and Eton relating to hunting, where it was held that native title was not extinguished by the Fauna Conservation Act. In Pasco Jamomira, Ricky Pasco, a 49-year-old Aboriginal man, was convicted of rape of a 15-year-old Aboriginal girl. Pasco claimed that she's my promised wife, I right to touch her body. and whilst he knew it was an offence called carnal knowledge, he said, "It's Aboriginal custom, my culture, she is my promised wife." This was in 2003. In the Magistrates' Court, Pascoe was sentenced to 13 months imprisonment. That was reduced to 24 hours on first level of appeal to the Supreme Court on the basis that he had been acting in accordance with his custom. But in the Northern Territory Court of Criminal Appeal, it was found that this reduction in his sentence was manifestly inadequate. As Chief Justice Martin observed, notwithstanding the cultural circumstances surrounding this particular event, the protection given by the law to girls under the age of 16 from sexual intercourse is a value of the wider community, which prevails over this section of the Aboriginal community. To hold otherwise would trivialise the law. And the Court of Appeal, Criminal Appeal, imposed a sentence of 12 months imprisonment, suspended after 1 month. The High Court refused special leave to appeal, and this audience is sufficiently and very much so knowledgeable to know of the law in Beazley and in Munda. This brings me to sovereignty. I have spent some little time reviewing Aboriginal identity and recognition of customary law, but there are indications that for Aboriginal Australians, sovereignty remains an unresolved issue, as is apparent from the claims of Aboriginal sovereignty made in the second half of the 20th century, both before and after Mabo. All claims have failed. There was the Bark petition of 1963, presented by the Yolngu people of the Arnhem Land to the Federal Parliament, protesting at the government's sale of 300 square kilometres of their land on the Gove Peninsula to enable bauxite mining by Nabalco. That had been done without consultation with the community. That petition failed, and so they turned to the courts. And that is the case, again, well known, of Milcombe and Nabalco. Whilst Justice Blackburn referred to the subtle and elaborate system which evidenced a system of government of laws and not of men, His Honour felt compelled by Cooper and Stewart to dismiss the claim. But although that claim failed, it seems that this case, and perhaps more than others, brought attention to traditional connections to the land, which ultimately received recognition in Mabo. In the first Coe case, which was in 1979, before Mabo, the plaintiff brought his claim on behalf of the Aboriginal community and nation of Australia, challenging that 1847 decision of Brown, to which I had earlier referred, and challenging Cooper and Stewart. And Coe pleaded that British sovereignty was contrary to the existing rights, privileges, interests, claims and entitlements of Aboriginal people. Chief Justice Gibbs, with Justice Aiken agreeing, acknowledged that a challenge to Milumpum and Nabalco was arguable. Justices Jacobs and Murphy accepted that Cooper and Stewart was open to challenge, but went further and observed that neither the High Court nor the Privy Council had ever finally determined whether sovereignty had been acquired by settlement or conquest, and that the question was justiciable as it might affect Aboriginal rights. However, on one point, the four justices were unanimous. Questions of sovereignty are not matters of municipal law, but of the law of nations, and are not cognizable in a court exercising jurisdiction under that sovereignty which is sought to be challenged. And this point has remained firm in the High Court's jurisprudence, including in Coe number 2 and in Mabo. In Coe number 2, 1993, Mr. Coe again sought to agitate the question of Aboriginal sovereignty, a claim which was met with almost peremptory rejection. Chief Justice Mason said that the first Coe decision lent no support whatsoever to a subsisting Aboriginal claim to sovereignty, and was likewise emphatic that Mabo number 2 was entirely at odds with the notion that sovereignty adverse to the Crown resides in the Aboriginal people. Nor, he said, did Mabo number 2 recognise a limited Aboriginal sovereignty in the sense of being a domestic dependent nation entitled to self-government and full rights, which Chief Justice Mason described as simply another way of putting the sovereignty claim. A different tack was taken in Walker and the state of New South Wales, which followed closely after Mabo. Walker was charged with a number of crimes, including assault with an intent to commit a felony. As pleaded, his claim was that the states and Commonwealth had no legislative competence in respect of Aboriginal people, except at their request and with their consent. In oral argument, however, the point was significantly refined and it was made case-specific. Namely, the question became whether customary Aboriginal criminal law had been recognised by the common law in the same way that Mabo had recognised customary land tenure. The claim was rejected. Chief Justice Mason relied on three principles in doing so. First, the principle of equality before the law. Secondly, the principle of statutory interpretation that an enactment applies to all within the territorial reach of the statute. In this regard, His Honour emphasised that the criminal law is universal in its operation. And thirdly, noting the early Federation authority of Quanyick and Hines, affirming that the general provisions of the criminal law were introduced by the Australian Courts Act of 1828, His Honour observed that Australian criminal law did not accommodate a parallel or alternate system of law operating alongside it. In Love and Toms, the appellant's argument, as summarised by Chief Justice Kiefel, was that the connection of Aboriginal Australians to the lands and waters of this country was so strong that the common law must be taken to have recognised that Aboriginal persons belong to the land. The appellants propounded a test of Aboriginality analogous to that in Mabo, but the flaw in their argument for Chief Justice Kiefel was that this would leave to the elders the determination as to who was a member of the group. Her Honour stated, to accept this effect would be to attribute to the group the kind of sovereignty that was implicitly rejected in Mabo No. 2 and expressly rejected in subsequent cases. Critically, for Her Honour and other members of the minority, Mabo decided that the common law of Australia recognised native title, not Aboriginal sovereignty. In the majority, Nettle-J noted that Aboriginal persons remain subject to and protected by the law in Australia. Referring to Yorta Yorta, His Honour considered that under the common law of Australia, an Aboriginal society retains an identifiable existence so long as its members are continuously united in their acknowledgement and observance of a body of law and customs. As it was the authority of the elders to determine membership of the group, a status recognised at the intersection of traditional laws and customs with the common law, and observations which had been made in Fejo and Yorta Yorta in the context of native title, Justice Nettle said that status was necessarily inconsistent with alienage. As can be seen from the approaches of Chief Justice Kiefel and Justice Nettle, the compass pointed in opposite directions from the identical starting point. Non-recognition of Aboriginal sovereignty on the one hand and the protection afforded by the common law on the other. Again, to an informed audience, I need not speak in detail about the stolen generation cases. Most, of course, have failed. There have been extraordinary number of legal impediments in the way. These impediments included being able to identify the correct defendant, one of the matters on which Cabello failed. There have been evidentiary impediments, expiry of limitation periods, causation issues, psychological and cultural impediments, all of which have been significant. And the impact of these impediments were measured in the Commonwealth Attorney General's 2009 report, A Strategic Framework for Access to Justice, which found that Indigenous Australians were the group most likely to take no action in response to legal events, 50.9% compared with 32% for non-Indigenous people. The significant point to make in relation to the stolen generation cases, it seems to me, is that claims based on the existence of a fiduciary relationship have all failed. And the commentary around this area is that those claims have failed, unlike those claims in, for example, Northern America, where there have been treaties in place which changed the nature of the relationship with the Indigenous persons and the Crown. And these are referred to in my paper. The genocide claims, likewise, have all failed, notwithstanding the Bringing Them Home report, which contended that the forcible removal and the assimilationist policies constituted genocide within the terms of the Genocide Convention. That, of course, has never been accepted politically and does not have the support of the case law, as we know from Kruger and Gray against the Commonwealth. One of the issues in that case was, and it was held, that for genocide there needs to be an intention to commit genocide, for there to be a breach of the convention, and as Justice Gummow pointed out, the ordinance rather evinced an intention to assist survival rather than destruction. There is a significant point of difference which emerged between the judgments of Justices Dawson and Gaudron, which is worth noting. Justice Dawson was of the view that Section 122 of the Constitution did not constrain the Parliament from enacting laws authorising genocide. He said, "The legislative power of the Commonwealth to make laws for the government of territories is sovereign and, subject to the possibility of any specific limitation to be found elsewhere in the Constitution, there is nothing which places rights of any description beyond its reach." Justice Gaudron, however, considered that Section 122 did not confer power to pass laws authorising acts of genocide as defined in Part 2 of the Genocide Convention. The acts encompassed in that definition, she said, are so fundamentally abhorrent to the principles of the common law that it is impossible to construe the general words of Section 122 as extending to laws of that kind. As I've indicated, sovereignty remains an unresolved issue for many Aboriginal Australians. As I've also indicated, an important attribute of sovereignty is the right to enter into treaties with other sovereign nations or entities. Paul Finn, Megan Davis and others have noted that the dominant difference between Australia's Aboriginal peoples and those of New Zealand and Canada is the absence of the treaty or substantial constitutional recognition. Such recognition in those countries altered the conception of sovereignty between the Indigenous people and the Crown. It's been argued, by contrast, that it's the absence of treaty which has had has at least a significant and negative implication for Aboriginal Australians' interaction with common law. Given that successive attempts to claim Aboriginal sovereignty have failed, other notions have been advanced, including recognition of Indigenous governance in law and policy. It has been argued that whilst Mabo recognised the land rights of Aboriginal Australians, it didn't recognise the system of Indigenous governance that underpins those rights. That, it is argued, is still to be determined. In its own way, it's been weighty and a huge slice of history. As I said, I do hope that you go away a little more knowledgeable. For myself, it has deepened my understanding of the claims of sovereignty and an understanding of sovereignty on both sides of the register, and it has most particularly given me a deeper understanding of the issues around Aboriginal identity. Thank you.
Thank you very much, Your Excellency. I now ask Emeritus Professor Ros Croucher to move the vote of thanks.
Thank you very much, Alan, as President of the Academy. Thank you, Your Excellency, for a most thought-provoking address. It's always a challenge in listening to our wonderful patrons' addresses to try and distill the ideas in a way that we can really share as the thing we take away. And I have to say, I loved your analogies or your pivot points. The first on seeing and the idea that if you close your eyes to the past, then you've got no opportunity to learn for the future. And that idea of seeing became, for me, a pivot point throughout some of the other remarks concerning the engagement of the common law, or laws generally, with the issue of our Indigenous peoples, their relationship to their lands, to each other, and to us. And the whole challenge reflected in the Mabo litigation and its antecedents was one of seeing, that we didn't see terra nullius in legal terms, was we just didn't see what was going on. And as we didn't see, we didn't recognise. And the whole concept of Mabo legally is about recognising native title. But it's such a limited thing because it's recognising a still point in a moment in time. It doesn't deal with the other issues of hearing, which you've also invoked as a point in your remarks, both hearing in terms of hearing language, and it was lovely to hear you speak at the beginning and acknowledging country and Gadigal, the ability to hear in evidence, but hearing is a matter that is going on, continuing. And so the seeing and the hearing to me became the pivot points, the leitmotifs in your very profound remarks. And it made me reflect on the kinds of things I've learned in the offices that I've held, and particularly as President of the Australian Human Rights Commission with an Aboriginal and Torres Strait Islander Social Justice Commissioner. It was the Human Rights Commission's report that spoke to genocide, and the other kind of work that the Commission has done. And the kind of issues that have become very powerful for me talk about seeing and hearing. One is the sense of recognising the decision-making that is reflected in sovereignty, but is also expressed as self-determination, not as a legal construct of sovereignty, but if you're going to make decisions about us, then you have to listen. You have to see us, recognise, you have to listen. And to see the Uluru Statement talk about the voice connects, I think, both to the seeing and hearing, which were the dominant themes for me in hearing your remarks. And it also made me remember something I heard when we conducted a function to celebrate an anniversary of the report that Sir Ronald Wilson led at the Human Rights Commission, and an adult man who had been removed from his family. He said, how do I know where I'm going if I don't know who I am? And that idea of recognition of identity, of seeing, for him was the thing he lost through removal, whether it was benevolent, malevolent, regardless, he lost his sense of identity. So seeing and hearing are the two keys, I think. So the solutions, of course, don't necessarily lie in law. The legal law has to play its part, but law is not always the answer. Law has a function, but there's a much broader sense of acceptance. It's both about seeing each other, it's about recognising each other, acknowledging identity, and the different histories that we all bring into the mix and complex mix of being Australians today. Our first Australians, our British history of settlement, and our new waves of settlement. All of them invoke ideas of identity and of listening. And I think if I take away from your conclusion, it invokes us all to listen so that we can see, and that in seeing we recognise and we understand. So that's what I've taken away from your very fine remarks this evening. And as the third successive female speaker to deliver our Patrons' Address, I also acknowledge the importance of that and your role as Governor of our fine state of New South Wales. We are very proud of you. as a fellow of our Academy, and delighted that you could give our Patrons Address tonight. And on behalf of the Academy, may I move a very personal and collective vote of thanks to you.
Thank you. Thank you, Commissioner.
Thank you very much, Professor Croucher. And those remarks bring this evening's proceedings to a close. Thank you all for attending, and this evening's events, I say, are now concluded. Thank you.